Hearing, my lord, an application filed by the husband, who is the petition before the trial court, is dismissed. The application, my lord, sought for a direction to the respondent to undergo for a medical test, proving herself that she is an impotent. Because, my lord, the petition is filed under section 12 of 1, saying that, my lord, she is an impotent. Because, my lord, it is an arranged marriage. She is also a stranger. But marriage is taken place in the year of 2015 itself.
Yes.
But there is no cohabitation at all between the parties. My lord, how, my lord, under what material, my lord, what can expect me to produce, my lord, before the court to demonstrate that, my lord, she is impotent or not impotent, my lord. Husband petition, my lord, challenging the orders of the trial court, wherein, my lord, an application filed by the husband, who is the petition before the trial court, is dismissed. The application, my lord, sought for a direction to the respondent to undergo for a medical test, proving herself that she is an impotent. Because, my lord, the petition is filed under section 12 of 1, saying that, my lord, she is an impotent. The decree of
That's allowed.
that is not allowed. The original petition is filed before the trial
For
court.
the
Husband, my lord,
yes,
he filed a petition under section 12(1), my lord,
yes,
seeking for a decree of, my lord, nullity of marriage, on the ground that, my lord, the respondent is an impotent. During the pendency of the proceedings, my lord, he filed an application seeking for a direction, direct the wife, respondent, to undergo for a medical test to prove that, my lord, she is capable to get married. That was came to be rejected, my lord.
How
There
this memo is moved? What is the urgency for that?
My lord, he, my lord, got married in the year of 2015. Matter, my lord, was laid before the trial court for 9 years. She has filed, my lord, against me a domestic violence. She has also prosecuted me under 498.
You also filed this writ petition of 2023.
My lord, the application itself is rejected in the, my lord, 2023.
We will pass orders. Please come to the order.
Lordship may kindly see.
Yes. Now that
Please.
you will say that she is impotent,
Please, my lord.
and you will send her to the medical test, and basing on that medical test, you will prove.
Please, my lord.
At what stage this application is filed?
My lord, it is, my lord, set down for evidence. Before the evidence, my lord, it is being
No,
filed.
no, it was filed in the inception itself. 2016 itself has been filed.
Even before any.
Yes.
What is the date of marriage?
Date of marriage, my lord, 11/6/2015, my lord.
When did you file this MC?
5/8/2016, my lord. Also enables a court. So,
First is you should make out a prima facie case.
please, my lord.
Court should be satisfied
Please,
while
madam.
exercising a jurisdiction of 115 or
Please,
227
madam.
that you have made out a case.
Please, my lord.
Then the court will order for that.
Please,
If the other person refuses it,
Please.
then the question of adverse
Please,
inference. So now the whole question is, have you passed on those steps?
Please, my
The
lord.
question, at what time you have filed this application?
This application is being filed.
Just you file your case and immediately you file an application. Is it a case that there is you have already made out a prima facie case?
My lord, when
No.
a petition is being filed under section 12, my lord, for seeking for nullity of marriage, my lord,
So
unless,
every-
my lord,
every
unless
person-
there is my lord, medical evidence, my lord, I can't prove, my lord, she is impotent. Because, my lord, it is an arranged marriage. She is also a stranger. My lord, marriage is taken place in the year of 2015 itself.
Yes.
My lord, there is no cohabitation at all between the parties, my lord. How, my lord, under what material, my lord, what can expect me to produce, my lord, before the court to demonstrate that, my lord, she is impotent or not impotent, my lord. Only, my lord, by way of medical evidence, it can be, my lord, examined.
Yes.
Next matter, my lord.
Palani Swami, which para?
My lord, this Palani Swami judgment, my lord, I have produced only for the reason, my lord, before the trial court, they have, my lord, raised an objection, saying that, my lord, there is no provision, my lord, seeking for a medical examination. And there is a error in the provision. That is the only reason, my lord, I have produced that, my lord. Even the error, my lord, can be neglected. That is
not
the only
necessary.
reason.
Yes. Next judgment.
Next judgment, my lord,
Zahida Begum.
Zahida Begum. Para number 3, 4, and 5, my lord. Married, my lord.
Yes.
Page number 48, running page 48, my lord.
Yes.
I have been taken through the impugned order with the assistance of the learned counsel appearing for the petitioner. It is no doubt true that directing either of the parties to undergo medical test in the circumstances is certainly warranted. The question is whether the defendant should be subjected to medical test or the plaintiff also should be subjected to identical test. It is to be noted that the specific case made out by the plaintiff petitioner is that the marriage could not be consummated as the defendant respondent was impotent and he was unable to perform the matrimonial obligations In the circumstances, the question whether the plaintiff petition is virgin or is not a wholly unnecessary. In the circumstances, learned trial judge would not have directed the plaintiff petitioner to undergo virginity test at the hands of the so and so. The question whether right of privacy is invaded in the matrimonial case where the parties are subjected to medical test has
Those
been
judgments are referred to in this. The earlier judgments are referred to.
Even in the
Sharada's
order.
case and all
Even in the order, it has been reflected, my lord. All these judgments have been.
in this judgment.
Lord, the para number 5 is very clear in this order. The order directing the defendant respondent to undergo medical test at the hands of the heads of so and so Kim's Hubli regarding potency is maintained. The order directing plaintiff petitioner to undergo virginity test is on so and so is set aside. My lord, it is permissible.
Yeah.
Next, my lord. Shiva Dayal.
Not Shivadaya. Next is Madhya Pradesh High Court judgment.
Please, my lord. Shiva Dayal. Oh, sorry, I'm sorry, my lord. Shantabai, my lord. That is, my lord, running page number 53, para number 6, my lord. On the bottom, last 2 lines.
Yes.
Whether it is found that after a reasonable time of marriage, there could be no copulation in spite of opportunity.
Are you reading para 6 or para 8?
6, my lord.
It starts with Srimati Shanti Bai.
And the last 2 lines, my lord.
After 1 month, she went back to her matrimonial home.
The basis on which, that is para number 5, my lord.
Para number?
That is in para number 10, out of that point number 6 in the last line. 53, last 2 lines.
The finding is at para number 11.
Please, my lord.
Applying these tests to the present case.
Before that, my lord, I would like to read, my lord, that point number 6 in page number 53, bottom of the 2 lines, right side corner. Last, my lord, 6 in bracket. Running page number 53, my lord. On the bottom right side, last 2 lines. May I read, my lord? Whether it is found that after a reasonable time of marriage, there could be no copulation in spite of opportunities because the other party refused to intercourse and resisted all attempts by the husband without just cause, the court would be right to conclude that the refusal arose from the incapacity to consummate the marriage.
I'm not able to find where are you reading. Are you reading this judgment of Madhya Pradesh AR 1966
Please, my
Madhya
lord.
Pradesh?
Please, my lord. That is, my lord.
Paras are very clear. Why this confusion?
My lord, para number 10, my lord. Page number 12, 53, 10.
Legal position on impotency.
The
is-
two
that's
legal
what it
position
starts.
impotency is
Huh?
in the very same para, last bottom second line from the bottom.
Whether it is found that after
Please, my lord,
reasonable.
please,
Yes.
please, my lord.
No,
Whether
if
it
you
is
say 6 in 10.10, the para number 10.
point number
people
6 in
understand.
para number 10, my lord, please.
Yes.
Whether it is found that after a reasonable time of marriage, there could be no copulation in spite of opportunities because the other party refused to intercourse and resisted all attempts by the husband without just cause, the court would be right to conclude that the refusal arose from the incapacity to consummate the marriage. Applying these 11, my lord, I'm reading 11.
Yes.
Applying these tests to the present case, in having given our anxious consideration to all the facts and circumstances, we have come to the conclusion that although the appellant is not structurally or psychologically incapable of allowing sexual intercourse generally, yet she has an uncontrollable aversion to allowing the courts to the petition husband. This case belongs to a rare variety of frigidity, quad hank, and we further find that such unconquerable aversion to the consummation of marriage existed at the time of marriage and has been in existence continuously. We are satisfied that these proceedings have been free from collusion. The parties appeared before us.
No,
endeavor-
once you have a judgment of the apex court, then
Please.
why do you want to rely on the judgments?
Please, my lord.
Yes.
All the judgments are following the very same, my lord. My lord, my respectful submission before this Honorable Court is, my lord. My lord, she was with me for very particular period of very short period. My lord, she never allowed me to touch her. And my lord, there is no cohabitation between the parties, my lord, according to me in my petition aversion. My lord, when such being the case, my lord, the husband cannot be expected to demonstrate or produce any document, prima facie document before the court to show that, my lord, she is impotent. Unless, my lord, there is a medical examination, my lord, by way of, my lord, order of the court. My lord, I can't demonstrate before the court. That is my grievance, my lord.
But the petition has been filed on 4/1/2016, man.
4-1.
2016.
You said 5/8/2016.
4/1/2016 was the date when the
That is after 6 months of marriage.
marriage.
Hmm.
So they had issued a notice to me on 26/12/2015.
26/12/2015.
Within 9 days, they filed the petition without even waiting for my reply to replying the notice. They filed the petition. Subsequently, the first week of January 2016, I filed the reply notice. We issued the reply notice to their notice, which is dated 26/12/2015.
Reply is when?
So first week of January 2016. By
First
that
week
time,
means what is the date?
it is a 7th month, 7/1/2016.
Uh,
They had filed the petition on 4/1/2016 itself. Now, my lord, the marriage has happened on taken place on 11/6/2015, my lord. 11/6/2015. The first nuptial ceremony has happened on 20/11/2015.
20?
11/2015. So subsequently, they started to live together as husband and wife. For my submission, sir, the marriage has been consummated. First submission. The second submission is, my lord, this petitioner wanted a divorce, my lord. Since as per Act is not, there is a embargo that within 1 year you can't file petition, they filed this petition for nullity of the marriage. So kindly come to para 8 of the petition, madam, which is at page number 30. Page 21, madam. Para 8 of the petition before the trial court. You may permit to read this one, madam.
Yes.
The petitioner further submits
Yes.
that during her stay at his residence, the respondent on 5/12/2015 has taken to gynecologist Dr. Bangalore for consultation. Even to the aforementioned doctor also, the respondent has not allowed her to test and to make preliminary inquiries. The doctor expressed that some counseling is necessary and detailed examination is required from the reputed doctors to test the maturity or otherwise health condition of the respondent. Now, kindly come to page 30, objection statement which the respondent has filed before the trial court. Para number 11. You may permit to read this particular para. In that one, my lord, there is contrary around after 8 lines, my lord, in the middle of the paragraph. Contrary to the above, the petitioner had forcibly, by misleading and manhandling the respondent without any intimation to her parents or to anyone, had taken to the said doctor, who is not a gynecologist, but is just a physician without any specialization, and the said doctor tried to make physical examination against the wishes of the respondent as regards to her bodily composition or her femininity, and the said doctor forcibly conducted the examinations and had declared that the respondent is hale and healthy and has no health issues, and her femininity and bodily composition is normal as like any other woman, and the said doctor had never prescribed any medicine or counseling or further examination as alleged. The above clearly demonstrate the sadistic attitude, nature and character of the petitioner towards the respondent. My lord, there is a document in his custody, my lord. Till date, he has not produced the document and has not laid the evidence. He has to prima facie prove his case. Until unless that is proved, this application is premature and it cannot be considered.
Please come. In this case, what all, yes, it is, now it appears that it's a case of the petitioner that whatever the averments that is stated in the petition is a prima facie case. In those averments itself, he has stated about the mediation that had taken place. He taking the wife to a doctor. He should put forth his case that by using necessary evidence that I'm under, he should make out a prima facie case in that. And in those circumstances, still, if the medical examination is required, and if the court comes to the conclusion that unless and until a medical examination is conducted, the petitioner husband would not be able to prove his case, and having satisfied that there is a prima facie case, then at that stage, either the application or the request that is made by the petitioner for examination can be considered, but it cannot be at a threshold without even using any evidence or without even making a prima facie case. A strong prima facie case, where the court will be compelled to asked the respondent to subject herself to the examination. In the considered opinion of this court, the stage at which the application is filed by the husband is not appropriate, and as on the while and he could not make out a strong prima facie case which can compel the court to pass an order subjecting the respondent to medical examination. In that view of the matter, this court finds no reason to interfere. But however, the liberty is given to the petitioner